Mr. Handte allegedly posted a TikTok video in which, in referring to the attorneys or judges or law enforcement people who he believes have wronged him, that it's time for them to go to the train station. That expression being, I believe, taken right out of the series Yellowstone.
All rise. The Second Judicial District Court, State of Nevada, is now in session. Honorable Barry Breslow presiding.
Thank you. Good afternoon, everyone. Please be seated. All right, welcome to Department 8. We're on the record in CR 19-1535, State of Nevada versus Stewart Handte. The court recognizes the prosecutor, Mr. Stege. Defense counsel recently appointed Mr. Day. Mr. Hante's present, and I believe it's Officer Kane. Is that right?
Yes, correct, Your Honor.
All right, thank you. Good afternoon. Welcome to all of you. We're here today because the court set a hearing on a notice of technical probation violation filed by the State of Nevada Division of Parole and Probation. Informationally, tomorrow the court is handling 14 criminal justice matters. 5 of them are hearings on probation violation matters. The procedural posture of this is not remarkable, to the extent that if the division believes there's been a technical violation, English translation for that, smaller, modest-sized violation, they file a notice, the court sets a hearing and decides what to do. If the division believes there's been a large, significant, more significant violation of probation, it files a notice of non-technical probation violation. But the process is the same. Mr. Hante's case, no exception. Just like tomorrow, there's a notice, there's a violation report filed. The court sets a hearing. Parties come to the hearing. The court finds out if the division maintains the position it set forth in its violation notice. The defense then advises if it admits factually what the division said happened, makes argument whether the court should deem that to be a probation violation, and if so, how to proceed. Alternatively, if the defense believes that the division has it wrong, factually, didn't happen, happened a different way, doesn't constitute violation, defense has the right to ask for a more formal evidentiary hearing under the Anaya case. So, shorthand for that is sometimes defendants accused of violating their probation ask for an Anaya hearing. And then the matter is set for a later hearing. We block off more time. We take testimony, if necessary, from witnesses. Court reviews evidence that's admitted, and then makes a decision whether a violation has occurred, and if so, what to do. In this case, again procedurally, several weeks ago, the division filed a technical violation report. In fact, the date of the report is September 18th. The shorthand, because everyone can read the violation report for themselves, but the shorthand for the at least 2 or 3 most significant concerns raised by the division are that Mr. Handte allegedly is reaching out directly to people that were involved in his criminal justice or possibly civil justice matters, emailing them, contacting them, posting things about them by name, and using extremely loud rhetoric that calls into question their concern for their public safety. Another item identified in the technical violation report is that Mr. Handte allegedly posted a TikTok video in which, in referring to the attorneys or judges or law enforcement people who he believes have wronged him, that it's time for them to go to the train station. That expression being, I believe, taken right out of the series Yellowstone, when it's indicated that if somebody's to be taken to the train station, it's because they're going to be killed and thrown off the train or something similar. So the not so subtle messaging there is it's time for those people to be hurt and or killed. Extremely concerning to the division, if this is occurring. And so in a moment, I'm going to ask the officer to identify in a little greater detail what the concerns are. Then I'm going to ask the defense if they concede any or all of the factual violations, and if so, how they would have the court respond. And if they do not, then would they ask for a deny hearing, and if so, how much time they anticipate needing, or anything else for the good of the order. So starting with Officer Kane, what can you tell us about what the division believes are the concerns and how it believes there's been a technical violation of Mr. Handte of his terms of his probation?
Yes, Your Honor. As you're aware, I'm not the author of this report representing the division.
No problem. Just slide the microphone. Do the court a favor. Slide the microphone just a little bit closer to you. Make sure that's okay.
So yes, according to the violation report, on May 16th, Mr. Handte was instructed on directives and conduct along with his other conditions of the interstate compact. Between January and September of 25, there was a recurring concern. January 22nd, the division learned he had been making threats against the Attorney General and other state officials. At that time, the investigator determined they were not serious, and Mr. Handte was instructed to cease. On April 29th, the division received a complaint that Mr. Handte was harassing Laura Gray, his father's guardian, and Willa Fons, the nursing director. His supervising officer in California informed him that division of probation. On June 12th, the division received a call from Story County Sheriff Collin. He reported receiving unwanted text messages from Mr. Handte. This was addressed to Mr. Handte by the California supervising officer. On September 3rd, 2025, the Washoe County Sheriff's Office received a call for service regarding a TikTok video Mr. Handte made titled "Set Up to Corruption, Stop Dirty Cops, Attorneys and Judges." I do believe that's when the violation report was first filed. That same video was also one where Mr. Handte said it's time for all of them to go to the train station.
Well, what's the division's understanding of what that means in the context of what's going on here?
The train station comment?
Yeah.
As you stated, Your Honor, it's a reference from Yellowstone, where the Yellowstone ranch workers would take people out, murder them, and throw them off a cliff, somewhere in state borderlines where they won't be found.
But first taken to the train station, I assume.
Correct.
Okay. All right, then what next?
Last one, most recently, September 4th, 2025, email was sent to several recipients, including Roy Stralla. Mr. Handte refers to this attorney as a useless piece of garbage and criminal cabal. The email stated rhetoric such as, "I'm not a man of violence, nor do I threaten any type of violence or threats thereof, but I am a man of conviction and will continue to do my diligence to bring down the criminal cabal which you are a part of. Your disgrace to Sigma Nu fraternity and absolute atrocity to alumni of the University of Nevada, Reno." This email was brought to the attention of the division, resulting in this violation report.
So is it the division's position that if some or all of these things are found to have occurred, it would constitute a technical violation of Mr. Handte's probation?
Correct, Your Honor. And ask for the recommendation of modifying.
Okay, so in the event we either if the defendant today concedes that this happened, And if the court finds a technical violation, the division is not asking the court to revoke Mr. Hante's probation, not asking the court to remand him to custody of the sheriff for an incremental punishment, time at the Washington County Jail, but something else. What's the something else?
Excuse me.
Sure.
We ask that his social media privileges be revoked and he be verbally admonished and that he ceases to do those kinds of communications.
Well, one of these is a text, so that's not social media, that's just text. Right?
Correct, communications with those parties. They would cease.
Okay, Mr. Handte, Mr. Stege, before I talk to the defense on what their position is on this, what's the state's position, please?
I endorse the recommendation. I think that we should all pause to remember that the court has the ability on this violation to send the defendant to jail for up to 30 days.
Well, if it's proven.
If it's proven,
Right.
if it's proven. And so I think it's useful also to remember why we're here. This defendant engaged in a crime in which he thought either the law did not apply to him because he had special privileges as a former, I'll use the word, law enforcement officer, or he relied on obviously fake legal documents. And so we get to sentence, and of course the history of the litigation up to the defendant's admission to guilt is that it was this stuff. It was harassment, it was vexatious litigation, it was engaging with others to encourage vexatious litigation, fraudulent pleading, sort of bizarre and sort of patently untrue legal theories. And so we get to sentencing, so the court, our statutes and our jurisprudence talk about rehabilitation of the defendant so that he might be the best citizen that he can be. And so part of what we're trying to rehabilitate is going back to the underlying facts of the case is this sort of bizarre belief in conspiracies, sort of conspiratorial thinking, approaching delusional thinking. And so we get to the court ordered the condition of no contact with people. I'm referring to B1, no contact with the victim, etc. The court personnel, judicial officers, DA representatives, etc. There's also a special condition about inflammatory rhetoric that is 8. Not stated in this summary.
Well, just so we're all clear what you're referring to. So you're looking at the judgment of conviction and the grant of probation and then the terms of probation that Mr. Handte is to follow.
That the court signed on March 20th of 24.
Which is, again, just to remind ourselves, that was about a year and a half ago. The probationary term here is a fixed 3 years. So we're roughly halfway through the 3-year probationary term.
Yes, and it's a rather favorable negotiation to the defendant. He has.
Well, hold on. Let me just remind myself. In the event Mr. Handte is successfully discharged, honorably discharged from probation, he's allowed at that time to come back and withdraw his guilty plea, and the judgment of conviction will be set aside, so he'll no longer be deemed a felon. Right?
Right. And so he's sort of on his way to revocation in the state's view or a dishonorable discharge. Not stated also he's behind on his fees and fines. But the court has authority under 176A 630, aside from revocation, to temporarily revoke, but can also, under 3A, modify the terms and conditions of probation. I think it is appropriate. The question of, I predict argument for the question of First Amendment rights. Now we should always pause as we consider sort of restrictions on speech, but.
Well, sorry to talk over you, but before I forget, the court did receive and review a First Amendment rights memo, or memorandum of law that was filed by Mr. Day, which were appreciated. But let's just remind ourselves, when you're on probation, you your constitutional rights are not, they're relaxed, but they're not asleep. I mean, you lose the right to own a firearm under the Second Amendment. You lose the right to have somebody only search your person, your belongings, your home with a warrant. But you know, warrantless search and seizure is generally a condition of probation, and so your First Amendment right can be curtailed, particularly whereas here there are concerns with the nature, the tone, and the expression here that is offensive, and so
Right.
that's a concern.
And it's, of course, not the first time he's engaged in this violent rhetoric, this sort of inflammatory rhetoric, which, you know, to remind ourselves, you know, the First Amendment does have limits, and it doesn't protect speech that incites violence. It does not. It's not the first time. You know, it probably fits on one hand, approaching two hands, a number of times the defendant has engaged in this type of rhetoric. The court is absolutely correct. The First Amendment, when you're on probation, it's also recognized by 176A400 under subsection 1. The court may prohibit the probationer from contacting or attempting to contact a specific person, et cetera, et cetera, et cetera. But the court can limit first and otherwise protected speech. This speech directed at threats, that's not protected. The court, in fact, already ordered that in the condition. So I would propose that the court, if there's an admission today, that the court add the following special conditions. That, now, he's already violated, I'm of the position that he's violated the condition on contacting the Second Judicial District Court. I'd also ask that he be enjoined to sort of reflect this rehabilitative purpose, be enjoined or prevented from filing fugitive documents or encouraging others to file fugitive documents. In this case, I think in this case, recently a number of fugitive documents were filed. One of those persons in a published case is a vexatious litigant, so he should not file, he should only file through counsel. He shall not engage with others to file fugitive documents. He shall not associate or communicate with anyone who has been deemed by a court to be a vexatious litigant. He should, the division is right, his social media privileges should be stripped by the court. It still has speech.
No Instagram, no TikTok,
No TikTok.
Facebook.
Facebook, TikTok, X, he's on YouTube, there's videos on YouTube, there's instances where it's clear he's associating with others in this sort of conspiratorial community to post videos about people associated with this court. There's one related to Your Honor that he's sort of conspired with or gotten together with. Because the rehabilitative purpose is this defendant needs to understand the wrongfulness of his actions and to avoid getting back to similar conduct, avoid future problems from this conduct. The emails, sort of blast emails related to this case should also be prohibited. It's problematic because many emails sent to court staff. The court already prohibited that and looked back at it. So that to me is a little more serious, but sort of underscoring that, putting an exclamation point by that would be in the state's view appropriate. Added condition. The division should also be granted authority as the officers see problematic relationships develop to add sort of people to the list of people that he cannot contact to further his rehabilitative purposes. And lastly, I'll say, Judge, there is reference to sort of mental health issues with this defendant. He, in the lead up to his admission of guilt, there were pleadings reference post-traumatic stress disorder. That should add a condition seek and maintain treatment for that condition.
Okay. All right, so you heard, so Mr. Day, we've now heard from the division the concerns that it believes are violative of Mr. Hante's probation. We've heard the state's view that in the event that those were proven to be true, then the state has this proposed remedial approach, does not involve attempt to revoke probation and send Mr. Hante to prison, does not involve, at this point, incremental punishment, 30, 60, or 90 days in the Washington County Jail, but instead to remind your client as strongly as the court possibly can, without changing his at liberty status, that certain things are not just off limits, but way off limits, directly or indirectly, and then to expand some of the restrictions and prohibitions that already exist to take into account what's been happening here. What do you think of all this?
Thank you, Your Honor. I mean, candidly, I'm chomping at the bit to argue some First Amendment points, but I don't think that's actually really, it's kind of putting cart before the horse.
Sure.
So, in going through this technical violation report, my client denies essentially each and every factual allegation.
Denies there's a TikTok video where he makes reference to take them to the train or the train station. I mean, that either exists or doesn't.
Well, for example, I've been unable to find that, hasn't been provided to me. He's
Challenging him.
Yes, challenge.
All right.
We go through individually, as some courts want me to do. For example, an allegation he was harassing a lower grade, his father's guardian, that number one, doesn't know who that person is. Number two, his father doesn't have a guardian. His father's been deceased for over a decade. So
So they have that wrong. They've confused him with someone else, or they have the wrong person, but for sure, Mr. Handy said, not true.
it's actually impossible.
Got it?
I can go through the whole list, but he denied his allegations. So I do think the only thing at this point we said in a hearing.
And have the division prove it if they can.
Yes, and so specifically I would request that leading up to it, they could provide these emails, and what's concerning to them. If I could be provided that, so we have it before the hearing, that would help the whole process along. I think we're entitled to see what these specific allegations are, that I don't have access to it either way.
I'm really unfamiliar with what the discovery rules require, or local rules of practice, or the Nevada rules of criminal practice with respect to pre-Anaya hearing discovery. It could be that there is a bank of information that must be disclosed significantly in advance, so responding party has a fair chance to review and rebut. It could be that the law doesn't require that, and we learned about it on the day of the Anaya hearing, exactly what proof there is that the division wants to identify and the state wants to seek to prove. I really don't know. Mr. Stege, do you have custom and practice on that, or can you refer the court to a rule of practice or otherwise?
Under the rules, there are no discovery or obligations. I think
How about custom and practice?
custom and practice variable. Most typically, the report suffices, of course, because the rules of evidence, there's no rules of evidence apply. So I don't want the court, I'll tell you, we'll do what we can, but I would resist an order from the court directing us.
Well, I'm not, okay, I can tell you this, I'm not anticipating an order. I'm encouraging fair play, and if there's a TikTok video that's referenced here, if it's available, it should be produced. If it's not produced, they're better, but it shows up on the day of the Anaya hearing, I'd really like to hear a good reason. If it doesn't exist, or it existed but you can't locate it, let Mr. Day know ahead of time so he's not preparing for a phantom.
Yeah, and I can tell you, the suspicion is the report comes out and the video is and I'm happy.
Well, the report's out, it's been out for 30 days now, so. Okay, and then to the extent you have witness or witnesses, the court would appreciate if you let the defense know, at least a couple of court days ahead, of who it would be and what you anticipate they're going to talk about. But am I ordering it? I'm not. Am I strongly encouraging? The court is. The court will have an anaya hearing. If in the event the court finds that the division and through its attorneys, the state have failed to prove that there's been a technical violation, then we're done. No further change of status needs to happen. On the other hand, if the state proves to the court's satisfaction a technical violation has occurred, then the court has available to it all the remedies available in such a case. I can tell you that as of today, based on even the concerns raised by the division, it's very telling to the court that they're not asking now for the court to to have Mr. Handte, even if these are proven or admitted, taken into custody. But if after the court hears all this, in the event the court does find a technical violation, then all remedies are on the table. So everyone should understand that. All right, anything else for the good of the order, other than for the court to direct you to set a hearing? The court starts a murder trial in 2 weeks, and it's going to take 7 or 8 days. It's going to have to be sometime in late November, early December. I'll let you, when the court leaves the bench, collaborate on potential dates. You can talk to Mr. Handte as well to make sure the date and time works for him. He has to be here in person. The court doesn't do these hearings remotely. As, for example, the 5 matters the court has tomorrow, they're all in person as well. Anything else from the state or the division at this point? Anything else from the defense?
There.
All right, court will be recessed. Please set this matter for an anaya hearing. Thank you, everyone.
All rise.